Hello, my name is Christopher Smith. I'm an attorney at law. My practice is located in Sarasota, Florida. I want you to know that bankruptcy is not an end, but rather it's a fresh beginning. For many of you, it will give you the opportunity to rebuild and restart your life free of the burdens of debt. But bankruptcy can be a complicated process as well, so I've prepared this short video to give you a general overview of the bankruptcy process. The information contained in this video is very general and could not possibly cover every aspect of a bankruptcy case. For more detailed information, I encourage you to speak to a bankruptcy attorney, such as myself, or you can read my bankruptcy guide on my website at chrissmith.com. Thanks for watching. So what is bankruptcy? Bankruptcy is the judicial process for modifying the relationship between a debtor and his or her creditors. It is such a scary word to most people, but it need not be, since it is designed to give a helping hand for people who need help with their debts. For consumer bankruptcy, there are two flavors called chapters. There's a Chapter 7 and a Chapter 13. In a Chapter 7, debtors liquidate non-exempt assets in exchange for the cancellation of their dischargeable debts. The liquidation process is overseen by a trustee who manages the case. In simple terms, a Chapter 7 is a case where you pay your creditors the value of your property that is not exempt, and in return, you forever discharge your debts. It is a fairly fast and cheap process and is the most common type of bankruptcy, but is generally only available to persons who do not have sufficient income to pay back some of their debts. In a Chapter 13, debtors commit their disposable income to a trustee for 3 to 5 years in accordance with a plan approved by a judge, and in return, they receive a discharge of their debts once all of their payments are made, even if they only paid back part of their debts. There is no liquidation, so debtors can usually keep their assets. This is a more complicated type of case than a Chapter 7 and is more expensive, but has certain advantages that will be discussed. A Chapter 13 is usually the only option for debtors who make significantly more income than average. So how does bankruptcy help? Bankruptcy helps in several ways. First, if you obtain a discharge, and most people do, you eliminate your unsecured debts. Unsecured debts are debts that are not secured against collateral. The most common types are credit cards, medical bills, and deficiency claims. A deficiency claim is the debt that arises after a foreclosure or repossession and is the difference between the value of the collateral and the amount owed on the debt at the time of repossession or foreclosure. Bankruptcy also helps by immediately stopping all collection action against you, such as legal proceedings, wage garnishments, and collection calls and letters. This will give you some breathing room from your creditors. Bankruptcy also helps if you are presently facing a foreclosure. A Chapter 7 will delay the foreclosure, typically by several months, to give you more time in your home and to give you more time to work out a loan modification or a short sale. In a Chapter 13, it can completely stop the foreclosure. Bankruptcy also helps if you have a second or third mortgage on your house that you want to keep, and if your home value is less than the balance on your first mortgage. In a Chapter 13, you can strip off those junior liens so that they are forever off your title. This can get you closer to eventually having equity in your home again someday. I'm delighted to report that a new case decision out of the 11th Circuit may now allow Chapter 7 debtors to strip junior mortgages. Stay tuned. In a Chapter 13, if the value of your assets subject to a secured debt is worth less than the balance on that debt, you can often lower the balance so that it is equal to the current value of the collateral. This is most common for cars that are worth less than the amount owed and would enable you to lower the balance on your car debt so that it is equal to the present market value of your car. You can also, through bankruptcy, discharge old tax claims that are more than 3 years old. In combination, all these benefits give the debtor a fresh start by wiping out most, if not all, of their debts. This frees up income that debtors can use to improve the quality of their lives, and it gives debtors valuable peace of mind knowing that their creditors are forever barred from pursuing them. Bankruptcy can be very helpful, but it does not fix all woes, unfortunately. As with any decision in life, there are pros and cons. For instance, bankruptcy will be a derogatory entry on your credit report for 7 to 10 years. It will impair your access to new credit and will usually require you to pay a higher rate of interest on any new credit accounts you receive for several years. It is unlikely you will have credit cards for at least a year following your bankruptcy, and you will probably not qualify for a conventional mortgage for several years after your bankruptcy. Bankruptcy does not discharge some types of debts, and these non-dischargeable debts will survive your case. The most common non-dischargeable debts are student loans, child support, alimony, recent tax obligations, and government fines. Plus, debts accrued or incurred through fraud, defalcation or malfeasance, or debts arising from intentionally harmful conduct can possibly be accepted from discharge if your creditor objects. Bankruptcy is not a private process. You will have to disclose information about your income, assets, and debts to a third party, and this information will remain in a court file. Bankruptcy does not impact criminal proceedings. Bankruptcy does not discharge debts arising after your filing date. This is particularly important for homeowners association or condo association dues, which often accrue monthly or quarterly. Therefore, after you file bankruptcy, you may continue to accrue HOA or condo association debts, even for a house or condo that you are ultimately surrendering in your case. Your bankruptcy will discharge the condo association or HOA debts that existed at the time of filing, but not those that accrue afterwards, since you are still the owner of your house or condo. Remember, the filing of bankruptcy does not remove you from the title to your house or condo. Only a sale or a foreclosure can do that. The filing of bankruptcy starts with the preparation of a petition. The petition is prepared after meeting with your attorney and his paralegal. You will have to supply your attorney with numerous documents, such as tax returns, pay stubs, and bank statements, to enable the preparation of the petition. You will also have to answer numerous questions about your finances and account for all of your debts and your income. If you are filing a Chapter 7, your attorney will determine if you qualify by running your income and expenses through a means test, which measures your ability to repay your debts based on your actual expenses and certain average expenses. If you do not pass the means test, then you must consider a Chapter 13 filing. You will have to take a credit counseling class before filing. There are dozens of schools where you can obtain your certificate. The process takes about an hour and can often be done online. The cost of the class ranges between $10 and $40 per person. Please note that after you file, you have to take a second class called a debtor education class. You will then review your petition for accuracy, instruct your attorney to make necessary changes and corrections, and then sign the petition. The petition can now be filed with the court. Your creditors will receive notice of your filing about a week after you file. About a month after you file, you must attend a meeting with your trustee called a creditors meeting or a 341 meeting. Your trustee will place you under oath and ask you questions about your petition and your finances. The meeting is tape recorded and typically runs between 7 and 15 minutes. In a Chapter 7, if you have non-exempt assets, your trustee will seek to administer those assets. This usually involves the trustee giving you the opportunity to buy back the non-exempt value of your assets. If you do not want to buy your assets back, you can turn them over to the trustee's auctioneer, who will sell those assets to pay your creditors. Unless there is a complication in your case, You usually receive your discharge about 2 to 3 months after your creditors' meeting. In a Chapter 13, you will have to start making your initial plan payments within a few weeks of filing. The plan payment may adjust periodically depending on the negotiation between your attorney and the trustee. Eventually, a confirmation hearing will be held in which your judge will consider the plan and the trustee's opinion of your plan. If everyone is in agreement, your plan will be confirmed. You receive your discharge in a Chapter 13 after all your plan payments are completed. For a Chapter 7, the filing fee is $306, and for a Chapter 13, the filing fee is $281. These are fees charged by the court. The attorney fee for a consumer Chapter 7 ranges between $2,000 and $3,000 for more complex cases. For a Chapter 13, the fee is usually $3,850, but you can usually finance part of that fee through your plan so that your upfront costs are lower. The fee covers a routine case, but there are situations where your attorney may charge you extra. For instance, if you have an adversary proceeding filed against you, your attorney may charge you an hourly rate to defend that action. In a Chapter 13, if you strip junior liens or utilize the loan modification program of the court, there is usually a supplemental charge that is added to your plan payment. This concludes the video. Thank you for watching. Please contact Christopher Smith at 941-907-4774 for any additional bankruptcy needs.